You know, what's going on with this petitions committee? Because the thing is, right, this is the thing with it. If you went to the supermarket, right, and you were selling boxes of screws, right, and for every 400 boxes of screws, right, 300 of them got returned because they were faulty, you would start thinking, what's wrong with these screws, And if you go to court, right, I'd be interested to know, that online small claims court online, the online small claims court, you can go online and you can claim money if someone owes you money. Although I think that the least thing that you need to use that for is money. I mean, people want to, claim things that, you're doing this and you're not meant to do it. Like YouTube, taking my videos down and you're not supposed to, or whatever. Money is the least of our problems. People want to claim against people because they're not doing what they're supposed to do. That's the point of a civil court. Why is it always over money? Usually it's over copyright. Have I got the rights or haven't I got the rights? It's not usually just about the money. It's about, getting the fact that you agree they are my rights or they aren't my rights, or I have got the right or I don't have the right. This is the problem. I actually think it now is that they're actually taking away. No one can afford to go to civil court and claim all these things and pay for these lawyers. They're way out of our price range, and it's only other companies who have got money, successful, profitable companies who can sue other companies, and then all those companies have been bought out by BlackRock, Vanguard, and then all the shareholder decisions are made by literally the same people in these networks of companies who will then all adopt the same policy and adopt the same staff training and adopt the same strategies across all the product brands and so forth. So it's not really companies versus companies anymore, because apparently, these big shareholders, it doesn't really matter whether they sell Twixes or they sell Mars bars or whether they sell Fox's biscuits or whether they sell peanuts. If it's all the same companies who own it all, then it's just like staring it's just having like a big, it doesn't matter who buys what really, because, it's all the same. It's just juggling. It's like Nancy Pelosi just juggling her shares around from one to the other. Twixes are doing better this week, so I'll move my stocks to Twix, and then, Babe Ruth's doing better the next week, and I'll move my stocks to Babe Ruth. But when, it's juggling, but you've got all the balls. And therefore, I think that civil court, where you get an order where I'm right, you're wrong, is limited now to people who have got crazy money. I mean, look at Stonehenge Tunnel, £135,000. And what the public have been relegated to now for civil claims is, if someone owes you a bit of money, or if someone owes you a bit of money and they haven't paid you for it, we'll give you a little quick way to get it back. But, we're not going to give you a way to claim. Oh, actually, they have in America, they've done CCCB in America, which is like copyright claims. If you want a little dispute over a video copyright, you can do it. But YouTube are exempt from copyright, so you won't be suing YouTube for it because they're not ever to be treated as another party. But yet you can't, go through there and say, YouTube, I've got a legal right in law to do this, or I've got a legal right in law to do that, and they haven't, because that's not over money, is it? That's over the law. You're not claiming money. So, in a way, all these phases of getting us out of access to justice or judicial decision making in the public, they removed us from the juries. You know, it's all like the councillors now make decisions for political parties and for executive branches of strategic planning of councils. The jury, the public, can't randomly turn up and decide, right, you're not building that road there, or, you know, you can't build houses there. Have a random jury of 12 people, right? It's all political party strategy and executives in councils who make all the decisions, not 12 people from the local area randomly, fairly chosen. Or even for any claims in a civil court between parties who have got a lot of money, you know, and then these lawyers are on ridiculous money that no one can afford, except companies and businesses that have all been bought out and taken over. And what those companies and businesses do through their training, is drill behaviours into people so they do as they're told, like on Star Trek Next Generation. And all these persons, individuals in companies who might not be aligned to this corporate objectives are weeded out, basically, you know. Or even if even if one of the factory owners or guys is opposed to what the other factories and brands are doing, it's trends, and they end up following these trends and manipulated into doing whatever. In fact, even in the pharmaceutical industry, some of the doctors have been saying that, you know, they've realised that, you know, what they're doing is wrong or not right, but a lot of them are under pressure. This is the whole thing with, you know, Fauci and things like that now. You know, this type of thing, we're getting people in these industries that are getting a bit more switched on to what's going on, and then this is the way the NHS has been orchestrated, and this whole pill pushing and so forth issue as well of one of those things. But anyway, so yeah, what was the point in that conversation? Well, that was about civil claims, like civil online claims, you know, access to law, access to justice, yourself, accessing it yourself. You can do it online, but they're limiting your access to money if it's about money, and not a lot of money. And the more money it is, the more and more the court wants from you, right? What I'm actually saying is that it's very, very difficult to prove something or get something officially proved through a court and get another party or another entity to agree with you. You know? Now, yeah, so these petitions, right? What are civil claims and civil online got to do with this petition? Well, what I was thinking is, and that was another long tangent of a conversation, going back to the civil claims. Why did I mention the civil claims? Because that website has got to have so many people using it, like every day or every week, right? And I was thinking, how, like, you know, whoever uses that civil online claims website is probably not going to be a big company, because big companies just go to court and get lawyers. They don't like DIY it online. It's mainly designed for normal people, like laymen, normal folks, like, you know, people who don't use massive law firms and companies. So it's got to be the same type of education and intelligence people who are doing the petitions website, right? Surely it's good, like average normal people, right? Now, what I'm wondering is, out of everyone who goes on that government civil claims website and submits a claim, which is to courts, to judges, to justices, you've got to write the claim out, and you've got to say, you know, you've got to make a case. I'm interested. This will be an interesting freedom of information to ask the Judicial Conduct Investigation Office, because they're actually subject to FOI, Freedom of Information requests. And that would be, how many cases were even submitted in 2024, right? How many cases were submitted to online small claims in 2024, right? And out of all those cases that were submitted, right, how many did they reject because they didn't know what the person was asking or they didn't understand the claim? Not for what the person won the case or lost the case, right? You can submit a claim to a court and you can lose. You can submit a claim to a court and you can win, right? But how many were rejected and not even entertained because they didn't understand what the person was claiming for, or they couldn't understand it, right? And I would be interested to know those figures, right? I'd be interested to know those figures. Was it 50%, 25%, 10%, or none? Did they understand every claim and either the person won or they lost? Now, if the figure is extremely low, if hardly anyone had a claim where the justices didn't understand what they were asking, or if there was very few to little or none, right, and either most of the cases either they won or they lost, then that makes you think that most people know how to write like a case to an authority where they pretty much know what they're asking, or it's easy to see what they're asking, right? So that wouldn't that make you wonder, why is it that the Petitions Committee and MPs, right, out of 493 submitted cases, only 63 were published and 30 rejected and given a reason why they were rejected. So it only looks like 30 were rejected. Now, if they actually did reject, if they actually truly did reject the other 493, if they did reject the other 493 petitions, then that would mean that 493 plus the 30, so about 400, over 5, over, so, just let me, 493, sorry, 353, sorry, unpublished, 353 plus the 350, 356, 383. So 383, sorry, 300, got my numbers mixed up. 383 are actually unpublished. Now, if the government on the petition's website, if it actually told you that amount and that number, right, if it said that, well, actually, there's been 493 petitions submitted, and if they actually said we've published 63, but we've rejected 353, bloody hell, then people would be saying, bloody hell, that's a hell of a lot of petitions to reject and not want to publish. It's quite a lot. In fact, there's only a very, very small number that you even let run. And that's not even saying you'll debate them. They wouldn't even get a judgment on them. They wouldn't even get a judgment where you win or you lose, where the MPs vote in your favour or against your favour, where so many MPs vote all the ayes or all the nays, all the yeas or all the nays. You know, if all the MPs vote on it and 50 vote in favour and 20 vote against it, then, you know, you win, right? So you won your case or you've lost your case, right? Like, you know, stop the ULEZ. Well, how many MPs vote in favour of stopping ULEZ and how many MPs vote against stopping ULEZ? Well, you either win or you lose. That's if it gets heard, right? But it seems to be that it's a competition or a contest to even get it running. So you can even attempt or try to get your 100,000 signatures to compel them to hear it, or to give evidence that it should be heard, let alone show evidence, if it does get heard, that it's a strong case that the MP should vote in favour based on the evidence. Not on their debate, remember. The debate is only that the strong evidence gets heard and voiced. And remember, you're the plaintiff. You're the one bringing the case and trying to make the case, not the MPs. The MPs are supposed to debate the matter based on the strength of the case. The MPs, all these MPs are the ones who compel the evidence and use the power of summons. It's a bit concerning, because it's almost kind of like, if you went to a court, right? If you go to a court, right, and you want to prove that John owes you £5, but you're limited to what evidence you can attach, right? They say, oh, you can't write too much. So you can say, oh, John owes me £5. And they say, okay, then, well, John owes me £5. I gave him it last week and he hasn't given me it back. Okay, that's enough information. Okay, it's clear what you're asking. We understand what you're asking. You're asking for the money back because, you gave it to him last week, right? Now, can you imagine if you submit that case, right? And this is the thing. What Parliament are doing is it's almost kind of like the judges then are the ones who decide on, they've not let you really give much evidence, so they're the ones who will look for more evidence and deal with it. Now, is that kind of a little bit like, you've got, can you imagine if the duty solicitor was kind of like acting for you, but you weren't able to submit much evidence? So the duty solicitor and the prosecutor themselves decided that they were going to take it upon themselves to go find some evidence. But remember, it's your case, and you're independent, and they're members of certain political parties who have got certain policies and clauses anyway. Now, would you trust the duty solicitor to make a thorough good effort of getting really good evidence, given to the fact that he might not be fully helping you or in favour of your cause? You just happen to be lucky enough to submit the cause, right? Which wasn't easy, right? Because you had to get 100,000 signatures to do it. And the prosecutor was actually against it, right? Now, for the MPs who turn up at these committee meetings, who are, you've managed to get them into debating your cause, but they might not be fully against it, like some of those Tory MPs who were claiming to be opposing ULEZ, right? They were giving evidence like, these ULEZ schemes are no good. That guy Doncaster says, oh yeah, it wouldn't be any good for Doncaster, or we don't really like them, or this or that. And they're talking about ULEZ, saying that, the Tories were saying Theresa Villiers and Gareth Johnson saying, oh, they're not that great, right? And then after the debate, then they vote they vote on it based on the evidence given. But what actually gets said is that the judge or the chair of the committee ends up saying, well, I now order all those in favour of, all those who what she effectively said, if I get it right, and I'll have to watch it back. I'll have to watch this back again, but we could get the video up. I'll make a separate video of that. But she effectively says something like, "We've debated ULEZ today," and then all those in favour of agreeing that we've debated ULEZ say yes, and all those opposed to agreeing that we've debated ULEZ say no. And seeing as only one Labour MP had turned up who opposed it, right, they all voted yes, because all the Tory MPs voted yes. And then they said, yes, and then she said, I now declare an order that today we debated Stop ULEZ, and then she slams the hammer down. So she just made an order that basically said that they debated the matter. She'd ordered that they debated the matter, but they didn't say debated it to what verdict. And the verdict was actually that they debated it, which was kind of ridiculous. It was kind of, I just couldn't wrap my head around it. It was just so insanely ridiculous. Now, what evidence was presented was what the MPs had gone and potted around and gathered themselves. Like that guy from Doncaster MP was just saying that, I've looked into this and it's not really going to be any good for Doncaster. It won't help us. We don't like these ULEZ zones. They're no good. But what evidence is that to... It's kind of almost like... It's almost like going into a courtroom, right, and then having someone who's robbed a bank, and then rather than putting evidence there and saying, yes, he did it, and then saying, right, you're guilty, and then go to prison, it's kind of almost like the duty solicitor comes in and says, well, I've had a look around, and people don't like crime in this town. They're not too keen on it. We don't really want any more robberies in this town, and we're not too happy about them, and we don't think that robberies would be good for this country. We think robberies are bad. And then almost kind of like saying, the court going, yes, well, everyone think robberies are not a good thing? No, they're not a good thing. Do we all agree on that? All those in favour say yes, and all those opposed say no. And then, almost like making an order, then saying that, robberies are bad, right? And then actually, what the court order is we've all agreed that robberies are bad, and we shouldn't have them, right? But they don't end up sending the person who just robbed the bank to prison, because the evidence that he robbed the bank was not really given. But they potted around and brought their own evidence in, which was just generally about the general subject. It was kind of ridiculous in a way. And this is kind of like, it's almost like the reason why supposedly practicing attorneys are not meant to be allowed to be judges. Because if a practicing attorney is allowed to be a judge and work as a judge, then when he's working as a judge, when he's working as an attorney, it's like judges are deciding what evidence is brought into courts and how cases should be presented that better suits judges and what judges and the courts want, not what the claimant wants and the outcome that the claimant wants and what the objectives of the claimant are. And that's really the monopoly on the legal system and the law, really, at the moment. The claimant, the person who wants to prove something and get something done, they are meant to bring the evidence. Now, you get a lawyer to help you because he knows the law, but you direct the lawyer, you direct the solicitor. And I think this is the difference between the police and the Crown Prosecution Service, and you bring in a prosecution privately. It's like having a monopoly on law, monopoly on justice, rather than, the citizens actually deciding what cases to prosecute and what evidence should be laid. And this is the thing with civil cases. If you want to win a civil case, like that Stonehenge Tunnel case, right? They brought a hell of a lot of evidence and they had 8 barristers, but those barristers are meant to know the law and they're meant to know which legislation and acts to use and what arguments to make. And